I'm calling to order the Ventura County Air Pollution Control District Hearing Board. Today's date is June the 8th, 2009, and it is 5:31 p.m. I'd like to ask the clerk, please, to call the roll.
I'm here.
Here. Here. Please note that we do have a quorum this evening. Let's see. I'd like to ask, we're going to be hearing today petition number 816 of Dos Cudras Offshore Resources LLC, known as DCOR, for a regular variance from Air Pollution Control District Rule 29.C, Conditions on Permits, Violation of Permit Conditions. I'd like to ask those that will be speaking today, please stand to be sworn in by the clerk.
You and each of you do solemnly swear that the testimony you are about to give in the matters now pending before this board will be the truth, the whole truth, and nothing but the truth. So help you God?
Is there anybody from the public that will be speaking today or giving testimony?
I have not received any comments.
Okay, thank you. Before you, the hearing board members, you have your packet. I'd like to ask that the petitioner please state their name and information and present to the board their information with regards to the petition, please.
Yes, good afternoon or good evening, and thank you, board members, for hearing this case today. My name is Christine White, and I'm an environmental advisor with DCOR LLC. And today we're going to be talking about our Mandalay facility. You hear okay?
Go ahead.
Yeah, we're going to be talking today about our Mandalay facility, which is located just south of the Reliant Power Plant. I was here about 2.5 months ago on March 16th, and we had applied for an interim variance. And what we're here for today is to turn this into a regular variance. But before I go any further, I just want to let you know that we have some very good news to report to the hearing board tonight. On Thursday of last week, we tested a water injection system on our flare in the bypass mode, and it was very successful. If you'll recall, the permit limits are 0.06 pounds per MMBTU, and we had a rate of 0.03 pounds per MMBTU. So we're well within compliance. Everything is looking really, really good. We did quite a bit of work since last March, and that's all detailed in the handout that you had. And I can go through those with you. But first, I have an exhibit, Exhibit 1, which are these photographs here, and that will actually help you understand what we've done. So let's take Exhibit 1, the photographs.
Yeah, I guess it should be noted that each of the hearing board members was given this packet at the beginning of the meeting.
Okay. In photo number 1, that actually is the looking at the flare, and that's our employees actually going inside of, one of the employees going inside of the flare to do some adjustments to that. The second photograph, that's actually looking into the window where you see the gentleman on the first one entering inside, and so you're looking into the flare combustion chamber, and those are the 6 burner elements. That's where the gas enters in and then gets combusted just above that. You can see there's 2 holes in the very back that are larger than the other ones, and the top one is actually the igniter, and the bottom one is actually where supplemental fuel would be added if needed to combust inside the flare. So if you go to photo number 3, the very next one, that's actually looking down one of those burner elements from a top view, looking down, and you can see in the very center there's a small hole, and that's actually where that's the nozzle where the gas is entering into the flare. So some of the things that we did through the time period, the first one was actually they tuned the flare up to make sure that the air adjustments and the temperature adjustments were all operating according to protocols, and the PEI representative that was out found that it was operating correctly. The next thing that we did was put on photograph number 4, they put these sleeves, or actually they call them spuds. These actually went into that small little hole at the bottom of the burner, and that was to increase the length of that the gas would flow through, and that would hopefully increase the velocity. That was tested and did not change the NOx level significantly, and those were then removed. So if you go to photo number 5, one of the next things we did was put in these air baffles on the outer perimeter of those 6 burners and in the center, and different variations of that. So photograph number 5 is actually, you can see the white, it looks kind of like foam or insulation with the black tie downs. That actually is along the outer edge of the flare, and that black on the lower left is one of those burner elements that I showed you. So we tested it with the outside baffles in. It did reduce it some, but not enough to be in compliance, but it showed that it was working somewhat. On the next slide, which is photograph number 6, this is actually the center baffles. This is actually a photograph that after they were cut down a little bit, but you can see that there's the 2 dark vertical things in the very top of the photograph. Those are the burner elements, and then you can see on the outside edge there, those are the outside air baffles. Okay, so those were put in and tested, and they actually didn't, the center baffles didn't help very much, and then they were later removed. So after doing all of this, and this was all prescribed by PEI, they're the manufacturer of the flare and the ones that warrantied that it would meet best available control technology limits, and actually have flares around the country with the same design that do meet these limits. They came back to us and said, well, those things didn't work. We'd like to design a water injection system or a water misting system. So that's what they took the month of May into designing all the specifications of that. And if you look on exhibit number 2, which shows it's an engineering drawing, that is actually the engineering drawing of the water injection system. And if you look on the very front page at the top right, you can actually see the burner element, one of those 6 burner elements. And what this system is it's putting deionized water into the center upper part of that burner element with a nozzle at the top, and deionized water is going to come out and basically mist as the fuel is coming up and then being igniting. And the purpose of that is to lower the combustion temperature. So that in turn would lower the amount of NOx that's formed. And we've just seen phenomenal results from that just last Thursday. So we're very, very happy about that. So the next steps for us are, we rig this up with just carbon steel, and in order to make this last and be a permanent fixture, we're going to have to put it in with a stainless steel so that it'll withstand temperatures for a long period of time. And then also automate the system, do some sort of automation so that when we are operating in the flare and the bypass mode, that this system will always be operating no matter what. So after we can get that in place, we'll be able to schedule emission source testing and get that test result, and within about a month and a half after the source testing, get the results over to Ventura County APCD. So what we've done is we've asked for a November 9th date for this variance to last until. We fully expect that we won't have to wait until that very last minute, but we didn't want to have to come back to the board, and we're advised of that by Ventura County staff. So I'm looking at probably doing the source testing sometime in the latter part of August, and then getting those results over to Ventura County APCD. A couple other things just to let you know. During this testing period that started on March 17th, we'd burned a total of 134 MCF in the bypass mode over 8 periods of time, 8 separate time periods where we were doing testing, and that's the only time that we've operated in the bypass mode was during testing. There was no emergency use whatsoever. If you use the emission factor that was agreed upon with the APCD, the excess emissions of NOx at this point are 0.004 pounds of NOx, which is very, very, very small. And I mean, we feel good at this point that we've gone through the steps that we need to do to bring this flare in the bypass mode into compliance. And I think that's all I can open up for questions for you at this time.
Okay. I'd like to ask the board to direct any questions they have of the petitioner, please.
Mine's probably a little premature, but have you reviewed the increments of progress listed in the draft variance order?
I know I've reviewed them, yes.
I just want to make sure you're okay with them and that you're going to meet those. We've had issues before where we've put in deadlines and we had to extend the deadlines. So I just want to make sure everything in the increments of progress is something you can meet. Absolutely. Is that a yes?
Yes.
You have to say it
that
out
is
loud
yes.
because they're recording it.
Yes. The answer is yes.
Okay,
And
that's
before
all.
I go any further, I'd like to introduce Bob Garcia. He's sitting to my right, and he's the Vice President of California Offshore Operations for DCOR LLC. So he also can answer any questions that you have.
That's all I have.
Thank you, Mr. Herlock.
I have a couple of questions. Did you say 134 MCF, not MMCF?
Yes, MCF.
I just wanted to make sure, do you have a permit condition number 4?
Okay.
And this variance has nothing to do with allowing variation of that, is that correct? This is just for condition number 8.
Well,
Or
to
permit
answer your
conditions.
question, on condition number 4, we will, this is 13 million cubic feet of produced gas is allowed in the bypass condition on an annual basis. So far, since we started operating the flare, it's 134 MCF. So we will be in compliance with that limit. We don't have any reason to believe that we'd exceed that for any reason.
But this variance, and maybe the district staff can clarify this if I'm not asking it right. This variance is not to exceed that limit.
No.
It's only to exceed the condition 8.
Yeah, this variance, my understanding is only being asked to operate in the bypass mode at an emission limit, at an emissions higher than what was permitted. We were permitted at 0.06 pounds per MMBTU burned, and when we did our source testing back in December, we were at 0.09, which is above our permitted emission limit. So we won't flow more gas through the flare, but the gas that throws through the flare is causing emissions to be greater than what is allowed in the permit. Is that?
Well, let me go to page 5 on the draft order. You have the draft order?
Yes, I do.
The paragraph under item 3 that talks about DCOR's authority to construct, that was just a little uncertain. This is not the subject of this variance. This 51.84, that would be the 6.5 days or something you referred to? Total
Yes.
flow?
If we burn the 13 million MCF, if we burned everything that was allowed at the higher emission rate, that would equal 51 pounds of NOx. That doesn't mean we've done that. That just means if we were going to
still within the restrictions of condition 4.
Yes, absolutely.
A little bit of follow-up to something that Ms. Neiswander asked you is under the increments of progress number 4, is it correct that you're planning to submit a report tomorrow, or was that a typo?
Yes, no, that is correct.
Okay.
I have the draft on my desk. I actually have a copy here, but I'll turn it in tomorrow. Just so you know, in the month of May, that report will be for the month of May, and during that time frame, PEI was basically designing this water injection system. And during that time period of May, we had no flaring in the bypass mode at all. So there were 0 excess emissions during the month of May. So that's what the report will show.
Just for maybe primarily for my own information, but do you understand why you have a different NOx level when the amine unit is involved rather than when it's being bypassed?
A different, a different,
I mean,
I'll let, yes, I understand your question. I'll
is
let
there some
Bob.
reason that the amine unit helps you meet your, I guess I don't understand enough about your system to see what difference that should make.
Well, the amine unit, what happens there is when it's in normal operation, we have what's called the tail gas or the residue gas that comes off of the amine unit. And during normal operations, that's what is actually sent to the flare for incineration. That tail gas is mostly CO2 with a little bit of BTEX, a little bit of hydrocarbons. That's why we have to send it to the flare to basically burn those off. The NOx issue is because there is a little bit of H2S that might go to the flare, and we just want to make sure that we meet those requirements on NOx.
Oh, I guess that's
So when we're in bypass mode, the amine plant is down. It's not producing this residue gas. It's high CO2, carbon dioxide, but rather now we're bypassing from our plant gases that would normally go through the amine plant, and they're bypassed around the plant to the flare.
So when
So
the
different
amine
NOx
unit
values.
is offline, you basically put your whole product that you can't sell.
Well,
through
it's
the flare.
gas that, yes, that could not be sold, but it has a different combustion characteristic, and that's why you have different NOx values.
We have the same permit limit, though.
Right.
Right, okay.
Yeah.
I don't have any more questions.
I have one question. I'm just curious, why did PEI give you information or tell you why the baffles did not work in your facility, yet you've said that they seem to work for other installations that they are involved with?
Well, my understanding is that they have flares of the original design that work at other facilities. I'm not sure if they have the center baffles that they had to put in on those other flares. Basically, the baffles were changing the air to fuel ratio within the combustion chamber, and I mean he basically thought that would help. But in these cases, it didn't. The outside baffles actually did lower the NOx levels, but not enough to be in compliance. And then when they put the center baffles in, that actually, I think, resulted in a slight increase. And so, they took those back out, and then they actually made them smaller and put them back in, and ultimately removed them 100% because it did not help. I can't tell you what they've done at other facilities. He's the engineer. He's the vice president of engineering, so I have to go by what he suggested to us.
That's good enough for me.
Yeah.
Thank you. Any other further questions? Okay, I'd like to ask the district to provide their position or comments as it relates to the granting of the petition.
Yeah, the district would support DECOR's variance request. We think they've done kind of really stepped up and made a lot of effort to try and resolve this issue. They've been very diligent in giving us reports and staying in touch with us. And the water injection into the flare, the final resolution is somewhat of a common NOx control technology for combustion sources, and it's used in a number of different applications. So I think from our standpoint, we see it as being probably a very viable approach.
Okay, thank you. And the petitioner is okay with that?
Yes, we are.
Okay, I guess at this point, my process is to close the hearing.
Mr. Chairman, I have a question of the district. In looking through the findings, and I don't have any problems. I've looked at them, and I have no problems making any of the findings. But I see finding 8 in here, and I thought we had gotten rid of that. Is that still in the rule book and hasn't been taken care of yet?
Yes, sir. It hasn't been taken care of in our rules yet, so
Okay.
That's why you're still seeing it. We did remove one of the previous findings. Right. We did remove one of the findings that we used to have regarding the expeditious compliance schedule, and in looking at it, we determined that that's not actually a health and safety code requirement or one of our rule requirements for the findings, so we did remove that.
Is there a rule change in somewhere in the system to get?
I keep asking our rule development staff, and it is on our rule calendar for this year.
I mean, if we get another diesel case, I'm probably not going to be able to make
it could be an issue.
finding number 8.
I agree. And just for clarification, Mr. Herlock, on one of your questions to Ms. White, this variance isn't intended to allow them to exceed their permitted bypass fuel limit that's specified in that condition 4.
And in that line, I think it isn't. Maybe I'm not seeing it, but I don't think it's spelled out as well as it might be that this is a variance of condition 8. It's covered and you can get to it, but I don't think it says that up front. Maybe it does, and I just missed it. But
on page 7, under the conclusions and order, it states that they're granted a regular variance from District Rule 29C, conditions on permits, violation of authority to construct, 01017-170, condition 8, and temporary permit to operate, number 01.
okay.
017-171, condition 8.
Right, thank you.
Anything else from district?
Nothing else.
Okay, thank you, Mr. Herlock, for bringing that to my attention. I'd like to close the hearing, and at this point, do we have a motion? No, I already asked. Yeah.
I would move that we adopt the draft ordinance that we've been reviewing here this afternoon.
Second.
Okay, we have a motion and it's seconded. Any discussion on the motion?
I've gone through, and I don't have any problems making any of the findings, but looked at each one, and I think I can make them.
And the same thing for Ms. Neiswinder?
Yes,
Winder, sorry.
I'll answer to anything.
I guess I could go through the findings, but I guess is that I'd like to ask council if I have to do that. I know at one point in time, the state in review said that we needed to be more explicit as we went through the determination and findings, but you know, it seems like the district has done a pretty good job in covering that in the recommendations, so I'd like to ask, should I go through that?
The shortcut we suggested was that you ask petitioner to verify everything in their petition and state whether they had any objections to any of the findings. Then I think you have then on the record, they have to fill out a form that shows the findings. So you have the data in there plus the district's summary of those same findings.
Okay, that's fine then. Thank you very much. Okay. At this point then, I'd like the clerk to call the roll for the motion.
Aye.
Aye. Okay, the petition is granted. Thank you very much.
Thank you.
At this point, is there anything that the district needs to identify, any other upcoming meetings at this point in time that we need to be aware of?
We are attempting to put together a hearing for, do we have a date? June 29th, an abatement order. We're trying to get information together to be able to file a petition this week. So if we can't get it filed this week, then we're going to have to search for another date. And we'll be in touch with each of you about that.
Okay, thank you. Anything from the board?
Any update on the search for a medical member?
I've touched base with a pulmonary doctor who did some work with us on a campaign a couple of years ago. No success there. I talked to my own physician with no success. Have a lead with a person at the American Lung Association that I need to pursue. We've also made another request to our Air Pollution Control Board for nominations, if they have any. Also contacted Dr. Robert Levin, who's the county public health officer, with no luck.
Chair Gasparino, I have a follow-up to a previous meeting question.
Yes.
If you want now. You had earlier asked about providing notices by mail or other means, and under your local rule 120 and also under the Health and Safety Code sections 40823A and B, it provides who gets the notice. And then 40827 of the Health and Safety Code says the hearing board shall serve a notice the time and place in the hearing either by personal service or by first-class mail postage prepaid. But it only applies to those people who are requesting it, which is the applicant, and the district obviously gets it by personal delivery. So the only one who has to get it by mail is the applicant, and the only other would be if someone had requested to get the updates. They would have to get them by mail, but otherwise it can be handled whatever's the most efficient way you want. This came up in regard to whether you could save on the postage and have two-sided pages and email and those kind of issues
right.
just to save paperwork. And this is the first chance we've had to talk since then, I think.
All right, yeah, I had forgotten that. Thank you very much.
Does that mean that email is not yet legal?
It's fine for your members, and it's fine for anyone except those who, under the code and the rules, have to get it by first-class mail or personal delivery. So email would save on all those, and that's how I get it every month by email.
Thank you very much.
You don't want to go to email as being a legal service, a legal method of service, because sometimes it just doesn't work.
Or people deny it.
Yeah, well, too.
Actually, I have a question with respect to that response. With regards to email, it's in situations where there is not a petition, but if there's a situation where something has to go to court, email must be provided as a means of the formal communication, et cetera, et cetera. But can, in an email situation, somebody put correspondence in something that's labeled attorney-client privilege to bypass that, or is that, I don't know where I just came up with that, but I just have a curious question now.
Could you rephrase it about the
Yeah,
privilege?
emails, I've been involved in EO cases and everything else, and emails regarding and surrounding the individuals in the case had to be provided, okay, whether you submitted the hard drive or printed copies. And at one point, somebody said if you had placed the emails in a file or a folder that were labeled attorney-client privilege, an email Outlook folder, then that would not be subject to disclosure to the other attorneys or et cetera.
Well, provided they haven't otherwise been provided to someone outside the privilege, that would be true, but you can't just by putting something in a file make it privileged unless it hasn't been communicated to a third party. Once you open up any document to a third party, you lose the privilege.
Ah, okay, okay, thank you. Anything else from the board? Okay. Motion to close the hearing?
Move to close.
Second?
Seconded.
All those in favor? Okay.
I think we have to vote on that.
Well, okay. The hearing board is closed.